One of the worst times for a family can be after a loved one passes away, especially if they have not set clear intentions for their assets or belongings. So what would happen if you were to pass away without a will? First, the state assigns a personal representative. If you die without a will, your estate will be intestate. Your accounts and assets will be frozen and no one will have access until a personal representative has been appointed. Items such as bank accounts, real estate, and securities can only be released once the estate has chosen a representative. But there are some exceptions. There are two exceptions to what will be frozen without a will: life insurance payouts and payable-on-death or transfer-on-death designations. When signing a life insurance policy, you select who you would like to inherit your life insurance should you pass away. If at least one of your beneficiaries survives you, the life insurance payout will not go through probate, and this does not have to go toward any debt you leave behind before being distributed. For payable-on-death and transfer-on-death designations, once beneficiary designations have been made, these will also be left out of the probate process, and beneficiaries must only go to the bank that holds the account and show proof of death for this to take place. There are some states that may require certain taxes to be proven paid, but otherwise there will not be a freeze for these funds. But what happens if you die without a will and you're married? The state will still assign a personal representative, and if you have a surviving spouse, they will typically be the personal representative. Situations with ex-spouses may be unique, and many will feel that they are the right choice for the job. Parents, siblings, and children are all options the state could choose, but if you are married, they will typically choose the surviving spouse. What happens if you die without a will and you're single? If you're single and do not have children, your parents are typically appointed as the representative and will inherit your entire estate if there is not a will in place, regardless of how weak or strong the relationship was with you. Any debt you have will first be paid by assets, and then the parents will get the remainder of the estate. If one of your parents has passed away, the rest of your estate, after debts have been taken care of, will be divided between your surviving parent and your siblings. When you are single and you have children, your children would inherit your entire estate. If your children are still minors at the time of the inheritance, the court can appoint a guardian to look after the inheritance until the child is of age of majority. In most cases, that age is 18, but they could be forced to wait until they are 21 years old, depending on state laws and inheritance amounts. A surviving parent can be appointed guardian of a child's inheritance, but in some states, if the inheritance is over a certain amount, a court-appointed guardian must be chosen. What happens if you die without a will and you're unmarried in a domestic partnership? If you're in a domestic partnership, the risk of not having a will in some states is greater than others. Some states do not recognize domestic partnerships, but if your state does recognize domestic partnerships, your domestic partner will be treated as a spouse and given the same rights. If your state does not, the domestic partner will not be named a beneficiary by the state. What happens if you die without a will and you're unmarried but in a relationship? In today's society, it is not uncommon for a couple to live together as partners without legally binding agreements. Unfortunately, without the legal agreement, a significant other would not be recognized during the division of your estate. Unmarried couples are not eligible to inherit property, assets, or belongings, and they would be divided among living relatives based on state-specific laws. And here are some more important things to consider. If you own property in more than one state, keep in mind one state will not be deciding the outcome for the entire estate. This could mean more than one beneficiary is chosen, since they will be governed by different state-specific laws. Moreover, taxes will be calculated on your estate, and each state's taxes are slightly different on estates. Be sure to look at your specific state for applicable law. Some states tax estates up to 16% if it's worth over $1.6 million, and other states have a specific formula to break down the taxes by beneficiary. Under federal law, your estate will be taxed 40% if it's worth over $11.7 million. Anything under that is typically exempt from federal taxes. We're eForms, the biggest online database of legal documents. We have a state-specific will template just for you, and you can get it by clicking on the link right here. And don't forget to subscribe first for more documents that will help you stay organized, and that is this button.